My name is Jeff Smyth. I'm an attorney in Seattle. The Washington Industrial Insurance Act promises injured workers the right to the best health care available, administered by the health care providers of the worker's choice. This was society's bargain for protecting employers from liability to workers injured on the job. All employers in Washington contribute to the labor and industries system to pay for these rights. Employees rely on the protections guaranteed by the Industrial Insurance Act and have done so for decades in the state of Washington. Washington encourages health care providers to treat injured workers with the promise of prompt and fair pay by the Department of Labor and Industries for their services. Continuing the broadest participation of doctors in the LNI system is critical to the health of our economy, which is why it's necessary to diligently monitor any movement which threatens to undermine the system. The current system is inclusionary. Any doctor who wishes to treat injured workers and is willing to abide the protocols of the Department of Labor and Industries is qualified to participate. For years, doctors in our state have efficiently treated injured workers exercising their best professional judgment to treat and hopefully return the worker to the job. That system is currently under attack. Supposedly in answer to the Washington legislature's call for more efficiency in the delivery of medical services to injured workers, the current medical director of the Department of Labor and Industries has begun construction of an exclusionary network. In other words, instead of being presumably qualified to treat injured workers, doctors are now largely presumed unqualified and must undergo an application process to seek membership in an exclusive club that will be eligible for compensation from Labor and Industries for treating injured workers. Who qualifies for that network is ultimately left to the discretion of one man, LNI's medical director. The initial screening for membership is not necessarily performed by Washington doctors, but rather by an out-of-state organization which ostensibly conducts independent peer reviews of doctors. That organization, I have personal knowledge, not only lacks the qualifications to judge Washington doctors, but it has in certain cases disqualified doctors based upon faulty or exaggerated information. More insidious yet is the plan of the new network authorities to dictate treatment methods for doctors in the network. This amounts to the unauthorized practice of medicine, and it further erodes the confidence of Washington's competent doctors to engage in the treatment of injured workers. Many with whom I have spoken see the new network as fundamentally flawed and a tool for those currently in power to blackball competent medical providers. We are currently investigating individual cases in preparation for a potential injunction action.